Welcome back to the Law Show on this Sunday morning. We're going to go back to our mailbag question bag and answer some questions from viewers in this final segment of the show. Again, this is the Law Show brought to you by the law firm Kerrigan, Estes, Rankin, McLeod, and Thompson. Our firm specializes and has for many, many years in representing people who are seriously injured in accidents. We represent families who have lost loved ones in accidents that were not their fault. We've done it for over 40 years, and we've hosted the Law Show over many, many years, and appreciate folks watching, and hope this is an opportunity where we can provide helpful information to the community. Our website is kerrigan.com. You can find a lot of information about the law firm, the history of the law firm, and individual information about each of the partners in the law firm. All of the lawyers with Kerrigan, Estes, Rankin, McLeod, and Thompson are partners in the law firm. All have a tremendous amount of experience, years of experience, representing people in personal injury cases, trying cases, obtaining verdicts and settlements to help people who are injured, who have economic losses, medical expense losses, and accidents that were not their fault. And we've limited our law practice just to those cases. And lawyers do a lot of other great things for people, estate planning, family law, divorces, criminal defense work, all sorts of things. But we have, almost from the inception of our firm, decided years and years ago that we just wanted to do this particular work, and we wanted to be specialists. And all of the lawyers who practice and handle cases here at the law firm are board certified civil trial lawyers, and a very small percent of the Florida lawyers are board certified at all, and certainly in this area of law. My name is Mike McLeod. My email address is on the screen now. It's mike.mcleod@kerrigan.com. You can send me an email, a question to me at that address. We'll answer it on the TV show, or I'll reply to your email. Again, it's mike.mcleod@kerrigan.com, or you can text us at our main number, 850-444-4444. That number is answered also if you call that number throughout the week, and actually 24 hours a day, 7 days a week, we can be reached at that number. So let's answer a few more questions that have come in over the last week or two. The first question is, how much does it cost to hire a lawyer in a personal injury case in Florida? So, and we've talked about this before, lawyers who do this sort of work and who handle these types of cases charge what is called a contingency fee. And the fee is contingent upon a successful outcome. So all those other types of things that lawyers do, criminal defense work, divorces, adoptions, estate planning, business issues, lawyers typically charge either a fixed fee ahead of time or an hourly fee, depending on how much time is involved in the matter. In personal injury cases, the contingency fee allows someone who may have modest means or who does not want to pay a lawyer up front, whether the case is successful or not, to hire the best lawyers they can hire. And the fee is typically a third of the recovery, dependent, again, on a successful outcome in the case. So if a person comes into our office who's been seriously injured in an accident, we will put the full force of our firm, and we have very talented staff who most of them have done this work and who have worked for us for a long period of time. We will put that group of talented people and lawyers forward to assist you to make sure you are treated fairly as a result of an injury resulting from an accident that was not your fault. And the fee is not paid up front. The fee is not paid at all unless there's a successful outcome. And so this allows the client to hire the best lawyers they can hire and not to pay unless there's a successful outcome in the case. And then again, also, there are certain expenses that go along with pursuing a serious injury case. And those expenses can typically be the cost of acquiring your medical records. Physicians and hospitals charge for the copying of records when the client needs them or when the lawyer representing a client needs them. So we pay all of those charges as the case goes along. Sometimes when we get records for the at-fault driver, what kind of driving record does this person have? We do a lot of research into, well, how is this person who caused this accident driven in the past? So we get their driving record. We get a lot of history and information on the person who caused the accident. That's available. Sometimes we hire experts who have specific training in certain aspects of how a case happened, not necessarily always an automobile accident, but other types of accidents. And then sometimes we will meet with a client's treating physician in order to have the doctor project how is this person going to do after the case is over. What's this injury? How is this injury going to affect them as they go forward in life? And so doctors charge for those conferences and for their time for providing this helpful information that helps us put forward our client's case. So the contingency fee is one that's not paid unless there's a successful outcome. The costs that we incur pursuing those cases, the things that those examples that I've just given, are not charged to the client at all unless there's a successful outcome. So what do lawyers like about the contingency fee? If a lawyer is talented and able to get a very positive outcome in the case, the lawyer is going to be compensated for the work that he or she does. And what do the clients like about the contingency fee? I can hire the best lawyers I can find, and I don't have to pay them anything unless they're successful in the case. And it opens the courthouse door and evens the odds against insurance companies. Typically, it's an insurance company who have plenty of lawyers, plenty of employees, who are all experienced in handling these cases. So it evens the odds for people that will find it hard to risk funds up front to make sure they are fairly compensated in an accident. All right, so next question was, what if the driver who hit me was drinking? So let's talk a little bit about drunk driver accidents. If a driver in another vehicle runs a stop sign, runs a red light, the most common accident really is a rear end collision. It's just human nature. We get distracted by different things. Cell phones are, of course, a big problem. But drivers get distracted, so it's very common for a person to come to see us and have significant neck or back problems as a result of a real rear end collision. So if a drunk driver rear ends you, it doesn't mean that they're more responsible. If a car rear ends you, that driver is negligent in most cases and responsible for your damages. But if the driver rear ends you and is intoxicated, then the case sometimes takes on different qualities. One, insurance companies that insure drunk drivers are, in our experience, more alerted to the fact that this is a case where a jury may award more money because our insured was intoxicated than if the insured just looked down to try and pick up a pen that was dropped or something that was dropped, because the fault part of the case is more aggravated. And we know historically that juries in Northwest Florida, and I'm sure juries everywhere, tend to compensate people that are injured with the same injury in a more substantial way, because the at-fault driver was so careless as to drive while drinking. And so we think that cases where the at-fault driver was intoxicated result in bigger damages, even though the damages are the same as mom or pop who causes an accident inadvertently by running a red light. The second kind of difference that I would mention about drunk driver accidents is that in the typical case, a person injured in an accident has the right to be compensated for their compensatory damages in just the average case. And compensatory damages are lawful damages in Florida um, that are aimed to compensate the injured person, and to compensate them for their lost wages, their medical expenses. These are bills that they have to make the injured person whole. And in Florida, in an automobile accident, if you have a permanent injury, you're entitled to be compensated for intangible type damages, for pain and suffering, loss of the ability to do the things that you could do and enjoy the things that you could do before the accident. But these are all damages to compensate the injured person. In Florida, if the at-fault driver is intoxicated to the extent that their normal faculties are impaired, the injured person also has a right to claim not just compensatory damages, but punitive damages. And punitive damages are not necessarily measured by, well, what happened to the injured party, but what is the bad conduct of the wrongdoing party? How bad was the person intoxicated? Is this the second or third DUI that the at-fault driver had? So in Florida, if the at-fault driver is intoxicated, then the injured person has the ability to recover not just compensatory damages, but punitive damages, damages that are measured to punish the at-fault wrongdoing driver. There are some procedural steps that have to be taken by your lawyer, if you've hired a lawyer, before you can trigger punitive damages. And just basically, those things are, you have to get into the record the evidence that this person was intoxicated, or this person's conduct was so reckless as to be tremendously reckless. And then you have to ask the court to allow you to amend your complaint to seek punitive damages. So there are some differences in cases that lawyers who do this can trigger punitive damages to punish the wrongdoer. We'll have some more questions answered next week. I've run out of time for this segment in the show. I'm Mike McLeod. This is The Law Show, brought to you by Kerrigan Estes, Rankin, McLeod, and Thompson. And we'll be back again next week.